Arielle, how are you?
I'm good. How are you?
I'm good, thanks. My name is Doreen.
And I'm Arielle Iulio.
Welcome to Handwritten Estates. You're listening to episode number 614. Today we're discussing a case called Langrandeur Estate. The site is 2021 ONSC 3447. So Arielle, you brought this case to my attention. What caught your eye about the Langrandeur decision?
I thought it was pretty interesting and a well-written decision. It covers a lot of different issues, including the validity of a will, who should be appointed estate trustee. There's some family law issues intermingled into this case that complicate things a little bit and make it a little more spicy. So yeah, I thought it was a great decision for us to discuss today.
Yeah, I agree. It does, I guess, with most of our estate cases, start with some tragic facts. Keisha Langrandeur died in 2019 when she was only 41 years of age. She has two kids at this point. When they're before Justice Cullen, they are 19 and 17-year-old boys. But maybe can we get a little bit into Keisha's personal history with her ex-husband, her current spouse?
So Keisha, she was legally married at the time that she passed away, but she had been separated from her spouse, whose name is Gayton. They had separated in 2014, so they were living separate and apart for several years before she passed away, and they were in the midst of divorce proceedings, which hadn't been concluded. So Keisha and her husband had gone through a bunch of, family law disputes, including, it seemed, some custody battles, child and spousal support issues they were still dealing with. And Keisha had also made a Family Law Act claim for equalization of their net family property. So they were in the middle of dealing with all of those family law issues at the time she passed away. And prior to that, she had been granted an interim custody order for her two children, Noah and Evan. So they were living with her at the time she passed away. And also her common law partner, Yvonne, who I don't think they mentioned how long those two have been together, but it's presumed that they were in a common law relationship. And following Keisha's death, her two children continued to live with Yvonne. Apparently they had a strained relationship with their father, so they remained in Yvonne's household.
And when Keisha died at the pre-death stage of this family law dispute, it was actually on the record in the family law materials that it was Gayton who owed Keisha an equalization payment of $40,000. But, in Gayton's view, the landscape changed dramatically for him and in his economic favor when Keisha died, because when she died, she had a will from 2004 that was made after their marriage, but before their separation, that names Gayton as the sole estate trustee as well as the beneficiary of her estate. And lo and behold, Keisha has the good fortune of having some life insurance in place. And it's an $800,000 policy that Gayton also considers to be a policy that's payable to the estate, i.e. 100% him. And so I think anybody who's listening and watching this can kind of see where the conflict is going. At the end of the day, this matter before Justice Cullen is as between Gayton and the oldest son, the son who is 19, Noah, and the new common law spouse of Keisha, right? Gayton says he's the estate trustee, he's entitled to all of this money. The son and the new spouse is saying like, oh, wait a minute here. I don't think that's right. What about all the pre-death claims? And what about everything that's like been going on all of this time? So it really started with a notice of objection to Gayton's application for probate for a certificate that names him as an estate trustee to this will. Now, let's start with like that very first reason why you said this case was interesting, which has to do with the validity of the will itself. Tell us about the problems here.
Interestingly enough, so neither party was actually disputing the validity of the will. That was something that Justice Cullen flagged when she took a look at this case. So the problem arose from just on the face of the will. It's she questioned whether it met the formal requirements of the Succession Law Reform Act because it included both typed and handwritten portions. And so just on the face of that, she felt the need to address the validity of the will before giving any directions on how this case should proceed.
It's actually funny. I think this is actually an exactly one-page document that was before the court. So in a very small amount of space, what Her Honor sees was described in the decision is what appears to be a typed will. It was signed at the bottom by the testator, appears to be witnessed by two other people, but there also is all of these handwritten changes, all these handwritten notations, but nothing's initialed, nothing's dated. So it really gets into the question is that when did these handwritten changes get made, period? In whose hand did it come from? Who wrote it in? Was it written in before Keisha signed the will before two witnesses? Or was it written in afterwards? So really the valid terms of the will is very much in question. I definitely agree with Justice Cullen in that regard. But, Justice Cullen did mention that if the court can't be satisfied as to when these handwritten changes came onto the document and who made them, that in itself may invalidate the entire will. I'm not so sure if, it's necessary to go to that very extreme extent that just because you can't tell exactly when something came onto the face of a testamentary document, does that mean you actually necessarily have to throw out the entire document? I think from just what's been described in the reasons, what I can glean is that, if the handwritten changes don't speak to a revocation clause, and if the concern is the validity of the handwritten notations, whether or not it qualifies as a holograph will, it could potentially be something that is just sort of given no effect, while everything that's typed, if you can be assured with all the other hallmarks of valid witnessing at the time that Keisha signed, and you think it's just the typed content that she was signing, then that might itself be okay to survive. But there's just so many other things going on with this will that on its face, I think there are many things that could undermine that disposition to gain solely regardless, right? The boys have their very valid dependent support claims. And so, the court did leave this for another day. There was very, very little evidence before Justice Cullen about anything to do with the handwriting. And we're going to get to by the end when we're done covering everything that is going on in this decision, what Justice Cullen's next steps are. But it's an interesting lens into the thinking of a probate court. When we think oh my God, our probate applications are taking so long to process. Well, I guess it is good to be reminded of type of the variety of wills that might actually come before the court, what the registrars are seeing every single day, the judges themselves. And yeah, this is for sure a pickle.
It was just left to another day. So essentially what Justice Cullen decided was that at this time the will could not be accepted to probate, but the validity of the will could be argued later on. So
right. Yeah. And what was decided by Justice Cullen is just based on everything that was before him, all the issues is between the parties, what the will seems to say, regardless, of the validity, is that Gaten at the end of the day cannot be the person who is the estate trustee of Keisha's estate. He is in a conflict of interest in a myriad of ways. He has a conflict of interest with his sons. He actually has a conflict of interest with the estate that Justice Cullen correctly points out, which is his obligations to Keisha prior to her death. And it was clear from Gaines' evidence that he means to discontinue those claims against him if he's allowed to step into Keisha's shoes as the estate trustee, or even turn the tables around and just now try to seek equalization of that $800,000 for himself if there's an intestacy and he's not the sole beneficiary. So with all of that in mind, conflict was just too much, too obvious. Gaines cannot be the estate trustee, even though, you know, he was named. And this is a very, I think, like seldomly referenced provision of the Estates Act, but the court did look at Section 29 of the Estates Act and like consider whether or not this is one of those special circumstances where the court actually just has to appoint someone else, and that someone else being such person as the court thinks is fit to administer the estate. And this really was that case. Section 29 of the Estates Act is quite a mouthful, especially when we get into like subparagraph 3 and those special circumstances. But the court does get into quite a thorough analysis of it and the case law behind, you know, weighing like a motion for removal of an estate trustee, is it warranted, and all of that. So this is actually like quite a good decision to read for that particular point. And so let's talk about what the court then decides to do. There's just so many loose ends. All it kind of was able to get to with the very limited information before the court was just to say, okay, this one person is conflicted out of being the estate trustee. There's still a larger question. Well, then who is going to administer this estate? What are the terms of the administration? Like, is there a will? Is there not a will? I mentioned that insurance policy. Who is it going to be paid to? What about the dependent support claims? So how did Justice Collins decide to deal with the future in this case, Arielle?
So she did make some directions, and those were
I think some of the next steps that the court wanted was just Justice Collins wanted to be seized of the matter until at least an estate trustee is appointed, whether it be an estate trustee pending litigation, because, you know, one of the parties may decide to challenge the validity of the will. Justice Collins did not leave that door as being closed just because nobody was challenging the will before her. Then she did set a timetable to say, like, if anybody actually does want to challenge the validity of this will, they can do so within a set time period. I will be seized until these procedural steps are sorted out, and there is an estate trustee in place to look after the administration while the rest of the claims are ongoing. There was consideration about what to do with that RBC life insurance policy. Directions were given that if everybody agrees, the monies can just be paid into court and held in trust by the account of the Superior Court of Justice until, everything is resolved, and for this endorsement to be served on RBC so that RBC also knows like what's going on, what to do with the money. Because we've been only talking about one of the sons all of this time, because that happens to be the adult son who's 19, what did the court do in this instance with the 17-year-old, Arielle?
Yeah, so in this case, because he was 17 and I think he was turning 18 in June 2021, so very soon, the court decided to not involve the Office of the Children's Lawyer. And they left it open for any party to seek further directions as to that, whether the OCL should be involved or not. But at this point, the Justice Collins didn't see the need to involve the Office of the Children's Lawyer,
right,
given that Evan was already 17 years old and would be an adult in about a month. So.
Yeah. And then I think that's quite a practical direction for the court to give. Justice Collins wasn't saying like just because, there's only a couple more months to go until the younger son is 18 years old, that the OCL has no standing in the matter. He very much left it open for the OCL to actually come in and say, like, if you actually want to come back to my court before this 18th birthday, you're absolutely welcome to do so, and just schedule the time. But he did not require the parties to involve the OCL prior to the 18th birthday, and that, he is left it, the practicality is like flexible to the parties. Like, if nobody reaches a deal about what to do before the 18th birthday, it's fine to let the time run. And then, then the younger son can just sort of like get in here in his own right, see if he wants to join the retainer of his brother and his, then the new adult in his life, I suppose. On that note, it's definitely a worthwhile read. Again, like I don't think there are too many decisions written about Section 29 of the Estates Act. So have a look. This is the Langrandeur Estate 2021 ONSC 3447. Link to the decision will be posted on our blog. So that concludes our podcast today. Until next time, we want to thank you for listening. I'm Doreen. And
I'm Arielle Iulio.
Should you have any questions, please email us at webmaster@hollandhall.com or leave a comment on our blog. Thanks.